Time is now 9:33 a.m. Today's date is December 28, 2021. This is the time and place for our regularly scheduled business meeting. Would the commissioners join me in reciting the Pledge of Allegiance? Pledge allegiance.
I pledge allegiance to the flag of the United States of America and to the republic which it stands,
one nation, under God, indivisible, with liberty and justice for all.
Thank you, commissioners. That was a most disjointed Pledge of Allegiance. I would note for the record that all commissioners are present at today's business meeting. So we will get started. Is there any request for public comment in the Bollinger Room? Seeing none, as I understand it, there's no request for public comment online. All right, seeing no public comment. We have no changes to the agenda this morning. So let's move into action item number 1, which is approval of the commission minutes for the week of December 13, 2021. Is there a motion?
I'll make a motion.
That was Commissioner Pinocci. Is there a second?
Second.
Commissioner O'Donnell has seconded. Any changes to the minutes, additions, corrections? Seeing none, all those in favor of Commissioner Pinocci's motion to adopt the commission minutes for the week of December 13, 2021, signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. All right, let's move to action item number 2. This is Docket 2021.08.110, Citizens Telecommunications Company. Tina?
Mr. Chairman, Commissioners, thank you. On August 16th, 2021, Citizens Telecommunications Company of Montana, LLC, doing business as Ziply Fiber, submitted advice number 2021-2 to update several pages of its tariffs on pages where the company name is shown in the body of the tariff to reflect a name change to Ziply Fiber of Montana, LLC, doing business as Ziply Fiber. On November 1st, 2021, Ziply Fiber updated its filing to include updates to all of its tariffs in their entirety to reflect the name change in the header and footer of each tariff page. Staff recommends approval of the updated tariffs.
All right. Thank you, Tina. Thanks for joining us this morning. We don't get to see you often.
Not often. We used to have a lot of these telecom minor tariff changes, but we don't get a whole lot of them anymore. So
essentially what we're acting on is a name change.
Yep, that's all it is.
All right. Is there a motion?
Mr. Chairman, this is Commissioner Fielder. I move to adopt advice number 2021-2 in docket 2021.08.110.
All right. Is there a second?
Second.
Commissioner O'Donnell has seconded. Discussion?
Mr. Chairman,
Commissioner Fielder?
I'm pleased to see the update of these name changes because it has been confusing to try to figure out who's doing business as who in this particular case. This company operates within my district and it's thrown me a couple of times. So I was pleased to see this come through.
Thank you, Commissioner Fielder. Additional discussion? Seeing none, all those in favor of the motion signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Tina.
Thank you.
All right, let's move into our work session. Work session item number 1 is docket 2021.08.106. It's Northwestern Energy. Application for approval of interconnection procedures. We have 2 matters to consider today. One is to consider QF's motion to dismiss, and then I believe there's an accompanying motion to stay. Mr. Hamilton?
Thank you, Mr. Chairman and members of the commission. This docket, as you mentioned, concerns the August 4th, 2021 application from Northwestern Energy for approval to use specific procedures and forms for qualifying facility interconnection in Montana. As the commission is well aware, issues of interconnection and transmission upgrades, network upgrades have been reoccurring questions for the commission across a variety of PURPA dockets. Those questions stem from an apparent ambiguity that arises when Northwestern Energy uses the FERC pro forma versions of the interconnection agreements with QFs. Those agreements from the FERC level contemplate that the generator will be paying for transmission service. Transmission service includes an embedded cost of the transmission system. QFs, however, do not pay for transmission service, and as a result, they do not pay an embedded cost of the transmission system. So when Northwestern historically has used those FERC pro forma agreements, it has required some negotiation and understanding with qualifying facilities that they will not be receiving a refund for the network upgrades that the commission will assign as part of the power purchase agreement, which is entirely within the commission's jurisdiction. There have, over recent cases, developed a series of disputes about whether or not the QF can stand on the rights provided in those FERC pro forma dockets. So this entire contested case stems from that ambiguity and attempts to try to clarify what the proper procedures and form agreements are for QF interconnection in Montana. Now, we have a variety of interveners in this docket. Some of those interveners are QFs. Some of those QFs have filed the two motions that are currently before the commission today for resolution. I would recommend, as a procedural matter, that the commission address both of those motions one at a time. The first motion to address, by my recommendation, would be the motion to dismiss, since the resolution of this motion would moot potentially everything else the commission needs to discuss on this. The motion to dismiss is based on a variety of arguments from the QF interveners who have moved to dismiss. Those include an ambiguity between whether this docket is a rulemaking proceeding or a contested case proceeding. To touch on that briefly, rulemaking and contested cases are two entirely different concepts under MAPA, the Montana Administrative Procedure Act. Rulemaking applies when an agency like the commission adopts a statement of general applicability or a practice requirement that would apply to everyone who appears before the commission. Contested cases, on the other hand, deal with the legal rights and duties of specific parties. So in this case, Northwestern Energy has asked the commission for approval for it to use certain procedures and form agreements, not for the commission to adopt these procedures and form agreements across the state of Montana for all utilities. Because of that, I do believe that the correct way to look at this case is as a contested case rather than a rulemaking. And so by denying the motion to dismiss, the commission can clarify that this is in fact a contested case and it should proceed as such. The second critical argument in the motion to dismiss concerns the commission's jurisdiction. That is the authority of the commission to even grant the proposed relief or the requested relief from Northwestern Energy. It's clear under Montana law that this commission has broad supervisory and regulatory authority over public utilities, including Northwestern Energy. It's also clear under Montana law that this commission has the authority to set the terms and conditions of power purchase agreements between qualifying facilities and public utilities. Those power purchase agreements are part of a whole set of terms and conditions set across a variety of agreements that QFs enter with Northwestern Energy. And importantly, there's an order of operations there of which agreements come first on the road to petitioning this commission to weigh in on the power purchase agreement. The interconnection agreements proposed by Northwestern are part of that set that defines the total legal rights and duties and obligations of the parties in the context of a QF's interconnection with Northwestern Energy. So I do believe that under Montana law, it is well established that this commission has jurisdiction to consider Northwestern Energy's request. For those reasons, I would recommend that the commission deny the motion to dismiss and proceed with this docket. I'll pause now before moving on to the motion to stay, since the discussion of that motion to stay may not be necessary if the commission grants the motion to dismiss. I would also note, just for the record, that in the room are two members of regulatory staff, Neil Templeton, Will Rosequist, who have also been working on this docket and may be available for questions.
Thank you, Mr. Hamilton. Neil or Will, do you want to address this matter? They wave off. Very good. All right. I will make the motion on this one. I move that the commission deny the QF intervener's motion to dismiss. Is there a second?
I'll second the motion,
Second.
Mr. Chairman.
Commissioner Fielder has seconded. I will address the motion. So we've had a lot of process so far in this docket, to say the least. At least two, I guess you would call them status conferences with the parties. We've had a motion for reconsideration. We have a motion to dismiss. We have a motion to stay. We've had some discovery in this matter, I believe. All those matters point to the fact that indeed we are proceeding under a contested case proceeding and not rulemaking. I don't believe there needs to be much said about the semantics of the arguments here as to whether this is a filed an application or a petition. It's pretty clear under Montana law that judicial bodies, which we are quasi-judicial, are to look at the substance of what is in the relevant pleading, if you will, rather than the terms used in the title. It's clear that Northwestern wants the commission to approve new procedures and forms for QF interconnection because these procedures and forms would apply to Northwestern rather than all utilities such as MDU. I agree that this is a contested case rather than a rulemaking proceeding. Setting aside the semantics of that argument, I think the jurisdictional question is really the most important here. Having read all the briefing in this matter, and I appreciate the quality of work that's always done by parties that appear before the commission, so let me commend the parties for their briefing. Clearly, there are some drafting tips that Northwestern could take away from this experience. And I would recommend that they be more explicit in future applications about the particular commission authority they are asking the commission to invoke and work under. I do appreciate the QF intervener's argument to that effect. But again, I think we focus on substance rather than form. There is no doubt that this commission's authority is broad. Montana legislature has given us full power of supervision, regulation, and control over public utilities. More specifically, this commission has determined both the rates and conditions of contracts between qualifying facilities and utilities. And we have that authority under MCA 69-3603 sub 2. And according to specific FERC legal authority, this commission has the authority to assign interconnection costs resulting from QF interconnection. That statement of law is unassailable. Approving procedures and contract provisions is squarely within this commission's authority under both state and federal law. For that reason, I believe we should deny the motion to dismiss. Comment or further discussion from any other commissioner?
Mr. Chairman.
Vice Chair Johnson.
Thank you, Mr. Chairman. I concur wholeheartedly with your remarks. I would just suggest again, as I did a couple of weeks ago, that there's also here I think a real issue of public interest. If we fail to create the clarity requested by Northwestern in this docket, we continue to flirt with the potential of allowing a QF to recover system upgrade costs and avoid transmission costs. And I would just say again, that is a precedent we can ill afford to establish because it would shift all of that burden of cost to the ratepayers. And I just don't see any justification for that, Mr. Chairman. So I will join you in supporting the motion to deny the motion to dismiss.
Thank you, Vice Chair Johnson. Additional discussion or comment? All right. I would just note, following up on Vice Chair Johnson's comments, that what we're considering here today is essentially the jurisdictional question. We are not ruling on the merits of Northwestern's filing. It remains an open question whether the commission should approve Northwestern's proposal or some other terms and conditions. That's the ultimate question for this docket. Again, we're not deciding that today. That will be a question for another day. But as I stated, I clearly believe we have jurisdiction to consider Northwestern Energy's filing both under federal and state authority. So again, I will be voting for my own motion to deny the motion to dismiss. All right. I think we can do voice vote on this one. All those in favor of my motion to deny the motion to dismiss signify by saying aye.
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 Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. All right, Mr. Hamilton, we do have before us QF intervener's motion to stay. Would you address that?
Certainly, Mr. Chairman. So the motion to stay requests that we stop this proceeding, hold it in abeyance until the Montana Supreme Court has resolved the appeal in this CED case, or Consolidated Edison, which is a combination of the CED Wheatland, Teton, and Pend Oreille dockets that are currently pending appeal. In that appeal, the QF intervener, the QF CED has argued that the Montana Commission lacks the authority to assign them the network upgrade costs, which again has been something the Commission has done consistently over a number of years. They argue that if the Montana Supreme Court agrees with CED in that appeal, then the Commission's authority to act on Northwestern's application here will be removed, and that any effort invested in this proceeding will be wasted. They outline a standard for when a motion to stay should be granted, which is, and that standard, is discussed in the staff memo. Staff's recommendation and belief here is that they have not carried the burden of proof on that standard for granting a stay, because the argument essentially boils down to attorney's fees being wasted, staff time here at the commission being wasted, the commissioner's time obviously being wasted, and then also Northwestern Energy having to invest its attorney and resource time in the docket that could be mooted by the Montana Supreme Court. The problem with that line of reasoning is that it could apply in virtually any case pending before the commission if a party disagreed with the relief requested. They could argue that it should not be granted and that it would be a waste of time to even consider the application, and therefore it should be stayed. That would be a dangerous precedent to set. So staff's recommendation to the commission is to deny the motion to stay and carry on with this docket. If the commission decides to deny the motion to stay, then staff would reach out to the parties and have a discussion about what continuing process is necessary to move this docket over the finish line. Thank you.
Thank you, Mr. Hamilton. Will, did you want to weigh in at all? He waves off. All right. I am going to move to deny the motion to stay. But as part of that motion, I direct staff if my motion is granted to confer with the parties in this matter and to set up maybe a status conference to discuss the nature and scope of further process in this matter and to issue an amended procedural order. Is there a second?
Mr. Chairman, this is Commissioner Fielder. I'll second the motion.
All right. My motion has been seconded. Discussion. I will start. As Mr. Hamilton clearly pointed out, the burden here is on the moving party to meet the two-part test that we require for staying a proceeding. I believe the movements have failed to meet either prong of that test. Again, the question here is whether a stay is reasonably necessary or if there's imminent harm to the ratepayer by allowing this matter to proceed forward. In answer to both of those questions, I don't believe the movements have carried their burden of persuasion. In essence, the movements have argued that the resources invested in this proceeding will be wasted if the Montana Supreme Court concludes in the CED appeal the Commission lacks jurisdiction over interconnection matters. Let me address the substance of that argument. As I noted in the previous discussion, I don't believe that is a likely result, that the Montana Supreme Court will determine that we lack jurisdiction over interconnection matters, given FERC's clear legal position and authority on the matter. Moreover, this commission has been dealing with QF interconnection issues for years and likely will continue to deal with these issues in the future. Until recently, in fact, commission authority over QF connections was not really even a contested matter. This has been a recent development. And I think that history shows that we will prevail in the CED matter. But even if we stayed this proceeding, the same questions would continue to arise in current and future QF proceedings. So I don't believe it's in the public interest to grant a stay here on the theory that we would be conserving much in the way of resources, because really that's what we're tasked to do as a commission, is to make these determinations. In fact, it's more likely the resolution of the proceeding will save time and effort down the road by clarifying some apparent ambiguity in QF interconnection. I believe the prudent course of action here is to continue on with the docket and to allow further process for the parties to develop their legal and factual positions. As noted, if my colleagues agree with that reasoning, I would direct the staff to contact the parties to see how to move forward. Additional discussion. Vice Chair Johnson.
Thank you, Mr. Chairman. Again, concur wholeheartedly with your remarks and would simply add that I think the sooner we establish this clarity and bring policy into compliance with what has been longstanding practice of the commission, the better off we and the ratepayers will be, and frankly, the better off applicants will be, because they'll have a clearer understanding of the procedures as we move forward, Mr. Chairman. So I will join you in supporting the motion. Thank you, Mr. Chairman.
Thank you, Mr. Vice Chair. Additional discussion? Additional discussion? Seeing none, all those in favor of my motion to deny the motion to stay signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. All right. So, Mr. Hamilton, you're tasked with reaching out to the parties, please. All right, let's move to work session item number 2, which would be docket 2021.10.126. This is Montana Dakota Utilities Company, application of MDU for authority to implement a fuel and purchased power cost tracking adjustment for, I'm presuming that's contract service rate 35, to act on MDU filing.
Thank you again, Mr. Chairman and Commissioners. This docket concerns rate 35. It is a single customer rate from MDU. This is their annual tracking adjustment, so it's a true-up of their actual supply costs. It this year results in a slight decrease in the rate for the customer. The proposed tariffs submitted by MDU as part of this docket are designed to take effect on January 1. So staff would recommend granting interim approval of the proposed tariffs so that they may take effect without needing any recalculation of the proposed rates. From here, staff will continue to process this docket. We will continue to allow intervention. I believe the intervention deadline currently is set for early January. So we'll proceed ahead. If there is any discrepancy or issue that needs to be addressed to correct an error in the proposed tariffs, of course, the commission would retain the authority to do that as part of the final order. All of these interim rate adjustments are, of course, subject to refund and adjustment based on the final order. So staff would recommend approving the interim order. In your meeting materials is a draft of that interim order. I should note that there were a couple of corrections needed for dates in paragraphs 13 and at the end on paragraph, I believe it is 18 to correct the year. Also, of course, the service date will be updated to reflect today if the commission grants approval for the interim order. Happy to answer any questions the commission may have. In addition, Grant Fink from the Regulatory Division is available via Zoom to answer any hard questions you may have.
Thank you, Mr. Hamilton. Mr. Fink, did you want to weigh in at this point?
No, Chair Brown. Thank you.
All right, thank you, Mr. Fink. All right, is there a motion?
Mr. Chairman, I'd like to make a motion to support staff recommendations.
Thank you, Commissioner Panocci. Is there a second?
Second.
That was Commissioner O'Donnell, I believe. So the motion has been
Correct.
moved and seconded. Discussion? Discussion? Seeing none, all those in favor of Commissioner Panocci's motion to approve rates on an interim basis effective January 1, 2022, signify by saying aye.
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 Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Hamilton. All right. I would just note for the record and for the public that our next commission business meeting will be Tuesday, January 11, 2022. We will not be meeting January 4th. Seeing no business to come before us, I adjourn today's meeting.